Assalamualaikum warahmatullahi wabarakatuh to our lecturer, Madam Shahila, and our fellow friend. Today, our group will be presenting about the topic delay and extension of time and claim for loss and expense. Delay and extension of time. As we know, construction contract generally allow the construction period to be extended. Where there is a delay, is that not the contractor fault? This is described as an extension of time. Delay can be said when there is time overrun or need extension of time complete to the construction project. In generally, delay can be said as the situation whereby the actual progress of construction is lower than the planned schedule. This is an example of extension of time form. The form need to be filled by the contractor to apply the extension of time in construction project. Extension of time based on standard form of contract PWD Form 203A Revision 1 2010. Reasonable appearance that the progress of work is delayed, the contractor should submit a written notice to SO consists of causes of delay and relevant information with supporting document enabling that said officer to form an opinion as to cause and calculation of length of the delay. If SO give his opinion that the extension of time should be granted, as soon as SO able to estimate the length of delay, then certificate of delay and extension of time will be issued given as fair reasonable extension of time for completion previously fit under the clause due to any or more of the following event. Clause 43(1)(a) Force majeure as provided under Clause 58. Clause 43.1(b) Exceptionally installment waiver. Clause 43.1 Suspension of work under the Clause 50. Next is Clause 43.1(d) Direction given by the SO consequently upon dispute with neighbouring owner, provide the same is not due to any act, negligence, or default of the contractor or any subcontractor nominated or otherwise. Clause 43.1(e) Extra instruction under the Clause 5 hereof provide that such instructions are not issued due to any act, negligence, default, or breach of its contract by contractor or any subcontractor nominated or otherwise. Clause 43.1(f) The contractor not having received in due time instruction in regard to the nomination of subcontractor and supplier provide in this contract necessary instruction, drawing, or level for the execution of the work from the SO due the any negligence or default of the SO, provide that the contractor shall have specifically applied in the writing on a date which having regard to the date or completion state in appendix or to any extension of time then fixed under this clause was neither unreasonable distant for any unreasonably close to date on which it was necessary from him to receive the same. 43.1(g) Delay is given possession of the site as provided under the clause 38.4 hereof other than claim in effective insurance and performance bond. Next is clause 43.1(h) Delay on the part of artists, tradesmen, or other engaged by the government in executing work not forming part in this contract. Clause 43.1(I). The contractor inability for reason beyond his control and which he could not reasonably have foreseen at the date of closing of the tender of this contract to secure such good material and services as are essential to the proper carrying out of the work. Delay on the part of nominated subcontractor and or nominated supplier to perform their work due to reason as stated above in subclauses A to 1. Then the SO may, if he is the opinion that the extension of time should be granted as soon as he is able to estimate the length of the delay beyond the date or the time aforesaid, issue a certificate of delay and extension of time given as fair reasonable extension of time for the completion of the work, provide that all such delay are not due to any act, negligence, or default or breach of the contract by the nominated subcontractor or nominated supplier and the contractor or any of servant or agent such nominated subcontractor or nominated supplier or the contractor. Provide always that the contractor has taken all reasonable steps to avoid or reduce such delay and shall do all that may reasonably be required to the certification of the SO to proceed with the work. Provide further that the contractor shall not be entitled to any extension of time where the instruction or act of the SO are necessitated by the intent to remedy any default or breach of contract by the contractor. This is an example of extension of time. A is the overlapping time for the delay due to clause 43B and 43C. That is, for 15 days from 15 February 2000 to 29 February 2000. B is the overlapping for the time for the delay due to clause 43C and 43E. That is, for 14 days from 2nd of March 2000 to 15th of March 2000.
Next, I will present about the clause for extension of time in PEM Contract 2018 with quantities. In page 23, submission of notice and particulars for extension of time. In clause 23.1, it stated that the contractor may apply for an extension of time if there will be delayed beyond the completion date by any of the relevant events stated in clause 23.8. While clause 23.1a, it stated that the contractor shall give written notice to the architect within 28 days from the date of the architect instruction, confirmation architect instruction, or the commencement of the relevant event, whichever is earlier. Clause 23.1b, within 28 days, within another 28 days, the architect will give the opportunity for the contractor to submit any sufficient information. If the contractor fails to submit such particulars within the stated time or within such a longer period as may be agreed in writing by the architect, it shall be deemed that the contractor has assessed that such relevant event will not delay the completion of the work beyond the completion date. Delay by nominated subcontractor. Clause 23.2. If there is delay by nominated subcontractor, the contractor shall forthwith send a copy of such written notice and particulars to the national subcontractor concerned. Insufficient information. Clause 23.3. It stated that if the contractor failed to submit sufficient information within the 28 days, the architect shall give another 28 days from receipt of contractor's particulars under clause 23.1b for the contractor to resubmit the sufficient information. Certificate of extension of time. Clause 23.4 it stated that the architect shall subject to clause 23.5, 23.6 and 23.8 consider the contractor submission and shall either reject the contractor application with reasons or issue a certificate of extension of time with details within 6 weeks from the receipt of sufficient particulars, which means within the 6 weeks after the contractor submit the application of extension of time, the architect will decide either to issue the written notice of rejection or the certificate of extension of time before or after the completion date. Other consideration for extension of time. In clause 23.5, it stated that if any relevant events that can lead to a delay in architect's opinion, the contractor may apply for extension of time to the architects. And the architect needs to make sure that the completion date, the new completion date given, is enough for the contractor to do their work on time. Next, contractor to prevent delay. In clause 23.6, it says that the contractor needs to follow the new completion date from the extension of time given by the architect, so that there will be no more delay on construction work. Notification to nominated subcontractors. In clause 23.7, the architect shall notify every nominated subcontractor in writing, not oral, of each decision of the architect when fixing a later completion date. Relevant events. In clause 23.8, relevant events referred to in clause 23.0, which means in clause 23.8, it will explain the relevant events for the contractor to apply for extension of time. 23.8a, force majeure. Force majeure is if there is an error in contract document that leads to a delay in construction work, so the contractor can apply for extension of time. 23.8b, exceptionally inclement weather. If during the construction work the rain were pouring heavily, that can lead to a delay in construction work, so the contractor can apply for extension of time also. 23.8c, loss and or damage occasioned by one or more of the contingencies referred to in clause 20.a, 20.b, and 20.c, as the case may be provided always that the same is not due to any negligence, omission, default, and or breach of contract by the contractor and or nominated subcontractor. 23.8d, if the material from the supplier arriving late that lead to a delay in construction work, then the contractor may apply for extension of time. 23.8e, if the contractor not having received due time the necessary document under clauses 3.3a and 3.3b, the contractor also can apply for extension of time. 23.8f, if there is a delay of work for provisional sum and prime cost sum by nominated subcon, the contractor also can apply for extension of time. 23.8g, if there is a delay by the employer in giving possession of the site or any section of the site in accordance with clause 21.1 and 21.2, the contractor also can apply for extension of time. 23.8h, compliance with architect instruction issued by the architect under clauses 1.4, 11.2 and 21.4, which is the architect issue for EOT, so the contractor need to follow the architect instruction. 23.8I, delay on the part of nominated subcontractor for the reasons set out in clauses 21.4A to 21.4B of the PAM subcontract 2018, which is there is a delay due to nominated subcontractor. So the contractor also can apply for EOT. 23.8J, renomination of nominated subcontractors as set out in clause 27.11. There is a renomination for nominated subcon, so there is a delay of work, so the contractor can apply for EOT. 23.8K, delay on the part of craftsman, tradesman or other contractors employed or engaged by the employer in executing work not forming part of the contract or the failure of execute such work, which mean that there is a delay because of nominated subcon do not follow the contract document, so there is a delay of work, so the contractor can apply for extension of time. 23.8L, delay or failure in the supply of materials and goods which the employer had agreed to supply for the works, so the contractor also can apply for EOT because of this relevant events. Another relevant events that can lead to extension of time, as we can refer in clause 23.8M, is stated that if the employer do not follow the contract, so the contractor have the right to apply for EOT in order to redo the construction work. 23.8N, any act of prevention or breach of contract by the employer, the contractor also have the right to apply for EOT for that. 23.8O, due to war damage under clause 32.1, the contractor can apply for extension of time too. Next, 23.8P, clause 23.8P, if compliance with architect instruction issued in connection with the discovery of antiques under clause 33.1. For example, during the construction work, they found a gold at the construction site, so there will be a delay for the further work for the discovery of antiques, so the contractor can apply for extension of time. 23.8Q, compliance with any changes to any law, regulations, bylaw or terms and conditions of any appropriate authority and service provider. Before they start the construction, before they finish the construction work, they need to wait for the feedback from the authority, but because of some reason that the authority do not give the feedback during the due date, so there will be a delay on time, so the contractor can apply for extension of time. Next, 23.8R, delay caused by any appropriate authority and service provider in carrying out or failure to carry out their work, which means that there is a delay of work because of like other authority work like TNB doing their work in construction site that lead to a delay for the construction work, so the contractor can apply for extension of time. 23.8S, appointment of a replacement person under Articles 3, 4, 5 and 6. The contractor also can apply for extension of time because of that relevant events. Clause 23.8T, compliance with architect instruction issued in connection with disputes with neighboring property owners, provided always that such dispute is not caused by negligence, omission, default and or breach of contract by the contractor and nominated subcontractor, which means that there is a complaint from the neighbor around the construction site, so there will be a delay of work, so the contractor can apply for extension of time. 23.8U, delay as a result of the execution of work for which a provisional quantity is included in the contract bills, which in the opinion of the architect is not reasonably accurate forecast of the quantity of work required, which means that there is a changes in quantity in bills or quantities, so there will be, so the contractor need to apply for extension of time to do the construction work. Next is 23.8V, failure of the employer to give in due time entry to or exit from the site, which means that the employer failed to give the due date for the contractor team to enter or exit the construction site. So there will be a delay of work, so the contractor can apply for extension of time for that relevant event. Clause 23.8W, suspension by the contractor of his obligations under clauses 30.7 and 30.8. Because of this relevant event, also the contractor can apply for extension of time. Clause 23.8X is stated that if there is a suspension of the whole or part of the works by order of an appropriate authority, so there will be a delay of work, so the contractor also can apply for extension of time for that relevant event. Clause 23.8Y, any other ground for extension of time expressly stated in the contract, the contractor also can apply for extension of time for the relevant event too. Extension of time after the issuance of certificate of non-completion. In clause 23.9 is stated that if the certificate is already issued, the architect can grant an extension of time without refer to the clause 23.1 to 23.7. Architect's review of extension of time after practical completion, which means that within 12 weeks, the architect need to review and fix a completion date later than previously fixed after the date of practical completion review. So, whether you are reviewing a previous decision or otherwise, and whether or not a relevant event has been specifically notified by the contractor under clause 23.1. Here is the timeline as we can refer from clause 23.1 to 23.5. During 28 days, the contractor need to give the first notice to the architect, and then the contractor have another 28 days to give the second notice to the architect. Then the architect have 6 weeks to decide either to approve or reject the extension of time applications from the contractor. That's all from me. Next, I will pass to the next presenter to explain about claims for loss and expense.
Thank you to the previous presenter. Now I will present about claim loss and expense and clauses for loss and expense in standard form of PWD 203A revision 2010. Construction contracts generally allow the contractor to claim loss and expense as a result of relevant factor for which the customer is responsible for significantly influencing the progress of work, such as failure to give the contractor possession of the site, delays in receiving instruction, and instruction relating to variations and expenditure of provisional sums. For Clause 44.1, it means if throughout the duration of the project is carried out periodic progress of the work or any part has been materially affected by reason of delay, as Clause 43.1 C, D, E, F, and H, the contractor incurs losses or direct expense beyond a reasonable cost and where the contractor will not be reimbursed, which is payback by payments made under other provision of this contract. The contractor have 30 days from date of such incident or circumstance or direction to give notice in writing to the SO with the intention of claiming loss and expense with evidence stating the estimate amount of loss and expenses as clause 44.2. This clause explains that after 90 days from the date of completion practical work, the contractor should submit full details of all claims for loss and expense under clause 44.1 with all supporting documents required to enable the loss and expense to be ascertained by the SO. When identified, the amount of loss and expense ascertained by SO will be added to the contract amount. Clause 44.3. This clause states that if the contractor does not comply with Article 44.1 and 44.2, the contractor will be unable to claim and will not be entitled to the claim. Also, the government will free from all liability in connection with the claim. That's all from me.
Next, I will continue with clauses in PAM Contract 2018 with quantities about claims for loss and expense. Okay, firstly is 24.1. The contractor may make a claim for such loss and expense where the regular progress of the works or any section of the works has been or is likely to be materially affected by any of the matters expressly referred to in clause 24.3. Next is clause 24.1a. For this clause, it is about within 28 days, the contractor shall give written notice to the architect to claim for such loss and expense. Okay, next is clause 24.1b. The contractor should send to the architect and quantity surveyor QS comprehensive particulars of his claim for loss and expense, including with any relevant calculation to prove his claims. Within 28 days, after the events referred to in clause 24.3 have ended, if the contractor fails to provide relevant particulars within the stated time, the contractor will lose his right for loss and expense. Okay, next, clause 34.2. The contractor must keep contemporaneous record of all his claims for loss and expense and send full details to the architect. Then, the architect and QS need to check all the books, documents, reports, paper, and records that provided by the contractor. If the architect or QS requested any record, the contractor should provide a copy each free of charge to them. Okay, the next slide is for clause 24.3 is the matters materially affecting the regular progress of the works referred to in clause 34.1. Clause 34.3a, the contractor not having received in due time the necessary documents under clauses 3.3a and 3.3b, which are 2 copies of contract drawing and 2 copies of unpriced contract bills. For clause 24.3b, it's about delay of time. It is because QS take a long time to finish their works, such as to make a BQ. So basically, should have enough information to that the architect able to issue AI. Okay, next is 24.3c. Delay by the employer in giving possession of the site or any section of the site in accordance with clauses 21.1 and 21.2. Refer to clause 21.1 and 21.2. Different dates of commencement shall be stated in the appendix. If failed to state in the appendix, contractor may claim loss and expense. So basically, the client will be responsible. Okay, next is clause 24.3d. Compliance with a written instruction issued by the architect in regard to the postponement or suspension of all or any part of the works to be executed under clause 21.4. It means the architect said it had to be postponed of all or any part of the works. Before enter the site, make sure the insurance had been approved. After that, can continue working. So next is 24.3a. Delay on the part of craftsmen, tradesmen, or other contractors employed or engaged by the employer in executing work not forming part of the contract of the failure to execute such work. Next is 24.3. Delay or failure in the supply of material, and goods, which the employer had agreed to supply for the works. Next is clause 24.3G. This clause is explained about delay caused by the architect for the opening up for inspection of any work cover-up. Okay, we continue with the clause 24.3H. Any act of prevention or breach of contract by the employer. Next, 24.3I. Delay as a result of a complaint with AI issued in connection with the discovery of antiquities under clause 33.1. For clause 24.3G, appointment of a replacement person under Article 3, 4, 5, and 6. Next, 24.3K. Complaints with a written instruction issued by the architect in connection with disputes with neighboring property owners, provided always that the same is not caused by negligence, omission, default, and or breach of contract by the contractor and or nominated subcontractor. Okay, next is 24.3L. By reason of the execution of work for which a provisional quantity is included in the contract bills, which in the opinion of the architect is not a reasonable accurate forecast of the quantity of work required. Provisional sum is inaccurate quantity. For example, is piling. It depends on soil. Maybe there is a rock or something that we cannot predict. So next is 24.3M. Failure of the employer to give in due time entry to or exit from the site or any part through of or over any land by way of passage adjoining or connected to the site and in the position of control of the employer. Next is 24.3N. Suspension by the contractor of his obligation under clause 30.7 and 30.8. It's like the employer failed to pay the salary, so the contractor may claim for such loss and expense. And next is 24.30. Suspension of the whole or part of the works by order of an appropriate authority, provided always that the same is due to negligence or omission on the part of the employer, architect, or consultant. Okay, the last clause is 24.4. It's about the loss and expense shall be added to the contract sum and also interim payment if issued after the date of ascertainment. Okay, as you can see in the diagram, during the lockdown and MCO because of COVID-19 pandemic, there are 3 grounds that allowed the contractor to claim for loss and expense, which are force majeure, works suspended by architect, and compliance to statutory requirements as the contractor refer to procedure A and B as stated in the video. That's all from us. Thank you.